John Moseley. Unfortunately, our host is not here. Mr. McCormick is hosting this event, but he was cutting things too close, and he will see us at the next seminar at 1 o'clock. So, with no further ado, John Moseley has exciting news and riveting news for us. He was an eyewitness to the hearing yesterday, and always has something interesting to say.
All right, thank you. Good or bad news, I don't know. Interesting, I suppose. Don't mean to, I apologize to Mike Garrett to have the video set up. One lesson is we need to learn to expand or amplify our influence by using the techniques that are out there. We've got to get caught up on these things. But, and I didn't mean anything by it, but I figure anytime I get a chance to vote against myself, that's something I should take advantage of. So I want to vote for the other speaker first. Anyway, the theme, of course, for today and what we're doing is that we need to learn how things work. The Tea Party, I think, and many people just sit there and watch. How did we get these leaders? What is going on in our country? How did these people get to be elected? And with David Ray's speaking and these other issues, I think understanding the nitty-gritty of how things work is a very important part of not just waking up and reading the news and saying, how did that happen? And there's a little bit, I'm going to try to emphasize a lot of that in what I'm describing today, as well as giving you the news and those sort of things, because the import of what happened in court yesterday really shines the light back on who makes the decisions of the Republican Party of Virginia, which is what we've been hearing about otherwise. So I want to keep that theme in mind. It matters who is making these decisions. At present, Virginia's ballot access and election laws, or at least part of them, are unconstitutional. That's the outcome of yesterday. However, it's not going to change the presidential primary, which is a bit surprising. I was just signing a petition for Bob Marshall over here, and we're trying to figure out what district we're in. Although the federal judge didn't finally decide that, that's almost certainly going to change. There have been there's a Supreme Court case out of Colorado, and a local federal case in Arizona, and one working its way through the system, which David Ray got me to look up, Lux versus Judd. And that is almost certainly going to change our entire system as far as requiring the circulator of a ballot petition to be in the district that the candidate is running for. Now, of course, you probably all know, but the issue yesterday was that Rick Perry sued to get on the ballot for the presidential primary on March 6th in Virginia. Newt Gingrich, Rick Santorum, and John Huston joined that lawsuit, and but they focused on this one issue because it was the one where they had some clear precedent. That was whether or not the ballot petition signature had to be a Virginia resident, a registered voter, or eligible registered vote in Virginia, and that is clearly unconstitutional. But when Judge Gibney finally decided about 4:20 yesterday afternoon, the hearing went from about 10:15 to 1:45, and then he retired to figure out what he was going to do. What he decided was that basically they waited too long. Now, if people care about the legalities, he didn't actually decide. Everybody thought, I thought, I've said previously, and if I say something different today than what you've heard me say before, I'm revising and extending my remarks as more information is. So, more information has become available. This is the latest here. Is that I was always concerned that what do you do about it? You say, okay, what do I do? Let you all go back and start collecting signatures all over again? How are we going to do that? It's very common to say you have a legal right, but I can't grant you a remedy. That is the analysis that I expected. Here, he actually applied something like the statute of limitations called latches. He said, I'm not even going to decide that. He said, because you waited too long, I'm not going to decide anything. But he clearly said, because this is going to go up on appeal, or may very well go up on appeal, he said, I'm going to tell you my entire analysis. And in his analysis, he made it clear that if it weren't for that, I would hold that the statutory scheme in Virginia is unconstitutional, has to change, but I don't know what I could do about it. It's just too late. And specifically said, for example, he went through some detail about when each candidate declared, when they started to gather petitions, signatures and that sort of thing, and said the time that they should have brought this lawsuit was when they were trying to collect the petition signatures and said, I can't do it because I can't bring in people from out of state. Now waiting, that was the time for the lawsuit. Now, after the deadlines have passed, he said, you waited too late. So that's what that's about. Now somebody pointed out, I couldn't find this, but for example, Jamie Radke, she I think wrote a letter to the Speaker of the House of Delegates that pointing out how the congressional district lines haven't been finalized. So how do you get ballot petition signatures to get on the Virginia ballot for U.S. Senator when you don't know if the person, what district they're in, because the lines haven't been finalized yet? Her bringing that to attention is a more severe problem than the one that was found unconstitutional by Judge Gibney yesterday. And so this is going to be an issue. Who would have thought of all the things that would be an issue, this is going to be an issue, but our law is almost certainly going to change here in Virginia as far as the way you do elections here, on that point. And the issue is that, I know it sounds strange, some people are saying, well, what does that have to do with the U.S. Constitution? I mean, why is some of these things, like, how is that unconstitutional? Other things that seem just wrong, they're constitutional, but this is not. Why is it? The issue is primarily comes down to the fact that it burdens the First Amendment right of political speech and political activity and doesn't seem to serve any purpose. The reason why the courts have said that the residency requirement of the circulator is unconstitutional is because you don't really need it. Why do you even have it to begin with? Now, the State Board of Elections argued yesterday that it helps them be able to subpoena them. If they have questions about the ballot petition, like just happening over here, they can say, hey, what did you do? That they can subpoena somebody in Virginia easier than they can subpoena somebody who's from somewhere else. But the courts have said, and Judge Gibney echoed in his decision, that it's the voter who signs that really matters. And they could say that as a condition of signing, you submit to the jurisdiction of Virginia. So it's not really a big enough reason to have this requirement. And that's why, and it particularly makes even less sense to say, I'm in this place, but I can't get signatures right next door in the across the line. That makes even less sense. So it's a balancing issue of restricting speech. Now, some interesting things happened about all this because, I suspected some of the other candidates who did not submit, quote unquote, did not submit any ballot petitions. The implications, they did absolutely nothing. Well, that turned out, as I suspected, not to be the case. For example, Santorum apparently submitted 8,000. And he actually collected 8,000. And there's some dispute for some reason about whether or not he submitted them or not. His people said that, I'm going to get these mixed up, I need to get my, that he submitted it and they rejected it because it wasn't enough. They didn't accept them at all. The State Board of Elections says he didn't submit them at all. But these people did collect signatures. They just didn't bother, some of them, when they got to the point of saying we haven't met the total. Rick Perry's campaign, and I signed a petition for Rick Perry at the Loudoun GOP meeting some months ago. He testified, Joe Albo, that he had they had thousands of people lined up to come in to Virginia and collect signatures. Because they were trying to say, because they're trying to get around the point of saying that if you struck down this requirement, we could then qualify and be on the ballot. And that was the trick.